Your Honor, members of opposing counsel, members of the jury, it was the Parks gun, the Parks house, and the Parks responsibility. In today's trial, you've heard the tragic story of two best friends who gained access to a deadly weapon. And because of that, one of them is gone from this world forever, and the other is traumatized. In today's case, you've heard the plaintiff tell you a story. You've heard the plaintiff tell you that it was Hayden Duran's parenting that put that gun into the hands of those children. You heard them tell you that it was Hayden Duran's responsibility to control her child. It was Hayden Duran's responsibility to keep her child from going to the Parks home and accessing the Parks gun. But the defense came before you, and we simply stated that it was the Parks gun, it was the Parks house, and it was the Parks responsibility. While we offer our deepest condolences to the Park family, it is this courtroom's duty to focus on the law and the facts of today's case. On August 18, 2010, two best friends, Jesse Duran and Sydney Park, are left home alone in the Parks residence. Sydney knows where to find the combination to their gun safe in an unlocked drawer in an unlocked office. And together with this combination, the children rush over to the Parks' unlocked bedroom, throw open the Parks' unlocked safe, punch in the combination, and pull out the Parks' 6-shot revolver. These children then take this deadly weapon, this 6-shot revolver, and they begin to play with it. Now, the children's combination of curiosity and the easy access to the weapon would turn tragic. As when the two children move into the living room, Jesse asked Sydney if she could see the gun. But Sydney did not hand the gun to Jesse. Sydney threw the gun to Jesse. And in Jesse's moment of desperation, trying to catch that weapon, trying to catch the weapon she never should have had access to in the first place, the gun goes off. In today's case, the plaintiff is not the only one with the burden of proof. The defense has taken on what is known as an affirmative defense. We came before you intending to prove that the Parks were equally or more negligent, and as such, you must find the defendant not liable. In this regard, we have succeeded. The plaintiff attempted to prove their burden by calling 3 witnesses. First among them, Andy Park. Andy Park came before you and testified that the combination was kept in an unlocked drawer, that the drawer was kept in a filing cabinet in an unlocked room, that the safe was kept in an unlocked closet, and that closet was located in an unlocked bedroom. Andy Park also told you that Sydney had expressed interest in the gun's location and had correctly identified it. Next, they called Dr. Solo. Dr. Solo corroborated this through her review of all of the evidence she was given. That Sydney had asked about the gun, that Sydney had correctly identified the gun's location. Solo also told you that Hayden Duran could be commended for the steps she took to limit Jesse's exposure to violence in video games. Finally, they called Officer Dale Williams, who told you upon his investigation on the day of August 18, 2010, he found no locks on the drawer, the office, the bedroom, or the closet. That Andy Park had told him Sydney knew where all of the important documents are. You also learned that Sydney had been going through the drawer that contained the combination in May of 2010, and yet steps were not taken to secure the drawer, to secure the office, to secure the bedroom or the closet. The plaintiff, they told you their story. The defense, we told you our truth. We called 3 witnesses to corroborate this truth. First among them, Hayden Duran. Hayden Duran told you that she warned Jesse, that she sat Jesse down, they talked. She taught Jesse the dangers of guns. She warned Jesse about the dangers of guns. She limited the games that Jesse could play. She did not buy the gun accessories. Hayden Duran took steps. Hayden Duran punished. Hayden Duran taught, and Hayden Duran warned. All of these things do not make a negligent parent. All of these things make a parent who took the steps, who took the time, and who made the effort to educate her child. Next, we called the firearms expert Ash DeRosa, who through her expert analysis determined that the weapon was stored improperly, that the combination was kept in an unlocked drawer, and that any safe is only as strong as its combination. Finally, we called Jessie herself, who told you the story of 2 best friends who set out to merely play a game. They set out to play a game with a deadly firearm that they were easily able to gain access to. A deadly firearm that was kept in a safe whose combination was not secured. And the deadly firearm that would ultimately lead to the tragic accident that brings us here today. Ladies and gentlemen of the jury, we came before you to prove our burden by preponderance of the evidence. That is 50% in a feather's weight, more likely than not. The plaintiff told you their story. The defense, we told you our truth. That it was the Parks gun, it was the Parks home, and it was the Parks responsibility. Opposing counsel came before you and told you it wasn't that simple. Ladies and gentlemen of the jury, had the closet been locked, had the drawer been locked, had the bedroom been locked, this would not have occurred. Had a simple lock been put in place, this would not have occurred. We came before you to prove it was more likely than not the Parks negligence that put the weapon into those children's hands, and the Parks negligence that brought us to court today. We have met this. Now, as the jury in today's case, it is your job to exercise a great responsibility. You must analyze the facts and the testimony you've been presented and make a decision based upon that. But before you do, I ask you, what is more likely than not? Hayden Duran's parenting put the weapon into the hands of those children, or the improper weapon storage, the improper combination storage, put the weapon into the hands of those children? Thank you.